Thank you very much to ERA for inviting me. I'm very excited to be here. I wished I could be in Trier to see you in person, so I hope that's possible the next time. I'm going to talk today a bit about supervision in a law enforcement context of data protection rules, starting a bit also from the Europol decision that the EDPS issued in January. As Ramina already said, I'm a researcher at the Freie Universität Brussels, and I focus especially on the Law Enforcement Directive and the General Data Protection Regulation, but I'm also focused on the question of fundamental rights and the protection of fundamental rights when we process personal data. Okay, so I think let's start a bit with the Europol decision that we have from January. Here you see a news article about it by The Guardian. What was this decision about? So the EDPS, so the European Data Protection Supervisor, which is the supervisory authority of Europol, issued this decision and ordered Europol to delete certain data sets that they had received from the member states. This is the first time the EDPS had issued such an order, so an order to erase. And the EDPS is also only the supervisory authority of Europol since 2017, when there was this new Europol regulation. What did the EDPS criticize about these data sets that Europol was supposed to delete? The problem was that Europol had received a lot of data from the member states, and this data was not categorized. You have heard before from Anna that there is this obligation in the Law Enforcement Directive that all data has to be categorized according to the data subject it relates to. Yeah, so the EDPS had ordered Europol to delete it, and this was the data they were ordered to delete that was not categorized. So they did not do this, that it had to be always linked to a certain data subject, and that has to be specified if it's like a victim, a witness, a suspect, etc. And as you also heard from Anna, this is important to avoid stigmatization of people who end up in law enforcement databases. It's of course also important just to ensure that there's actually a link between law enforcement context and the personal data you're processing as a law enforcement authority. So Europol did not do this for these data sets. The member states, of course, who had sent the data also did not do this. So this was kind of a double problem. And now the EDPS has ordered Europol to delete it. What's interesting about this decision is that this decision was from January, and then a couple of months later, in May, so last month, the European Parliament confirmed that there will be a reform of the Europol rules. And under these new rules, Europol actually will have more powers with regards to large data sets, and this kind of problems that the EDPS was criticizing would kind of be now in a better legal framework, so the same kind of decision would not be taken anymore. We will discuss both of these things later. I just wanted to give you already a preview to phrase the discussions in. So what are we gonna talk about now? We're gonna start a bit with how data protection supervision works in a law enforcement context in the EU and how we arrived at this sort of patchwork. We then will go back to this EDPS decision I just told you about and think about what it means for law enforcement supervision. And then finally, we will try to look a bit at the future and what we can learn from a decision, but also in general from the patchwork. And I forgot to say before, if you have any questions or if anything is not clear, please just raise your hand. I think I should be able to see it, and then we can discuss it right away. Otherwise, there will be time after. Okay, so to go to data protection supervision and law enforcement context, I think the first important provision to look at here is Article 8 of the Charter, which is, of course, the fundamental right to the protection of personal data. So this is part of EU primary law. And one part of this fundamental right is that any sort of compliance with data protection rules has to be subject to the control by an independent authority. From this provision, we can already learn two important elements about supervision in general. The first one is that control, of course, indicates that this independent authority can take sort of binding measures against whom they are supervising. So they need to be able to actually effectively exercise their powers. And then the second, of course, is that these authorities need to be independent. This requirement of independence is actually something that was developed in EU secondary law. If you remember, the Data Protection Directive already had strict rules on this, which is the one from 1995. And this kind of provision has also been taken very seriously by the Court of Justice. So in the context of the Data Protection Directive, there had been decisions against Germany and Austria and Hungary for not having data protection authorities that were independent enough, especially not independent enough from the executive. Currently, we have actually a case against Belgium for the data protection authority under the GDPR, so the other legal framework, where the problem is that they have some people sitting in the data protection authority who also kind of work for the government. And the question is if this is sufficient independence then for the authority. So this will be very interesting. And the second provision we have to look at, if you want to understand where this requirement for supervision comes from, is Article 16 of the TFEU, which is the mandate that the EU legislator has to adopt rules in the data protection context. And also a part of this mandate is that all rules need to be subject to the control of independent authorities. So again, this requirement to have independent authorities, to have supervision in the data protection context is very strongly baked into the primary law. But of course, the area of law enforcement is special and is also special in EU primary law. So we have this Declaration 21 to the Treaty on European Union, which says that there can be specific rules also based on Article 16 of the treaty for data protection in a law enforcement context. So from the very start, it was perceived that for the law enforcement area, we might need special rules and specific rules that are different than the rules we have in a more commercial context. Of course, this is kind of a leftover from the pillar structure that we had before the Treaty of Lisbon to introduce the TEU. Because if you remember, before we had these three pillars, the third one was linked to law enforcement. And in this pillar, like member states could only make decisions anonymously, so together. And this changed a bit with the Treaty of Lisbon. Now it's ordinary legislative procedure, but it's still a bit special. And this declaration emphasizes this specialness. And why is it special? Because of course, law enforcement is a kind of a delicate competence, and member states are probably not fully comfortable yet to have the same amount of harmonization than they might have in other fields. However, even with this declaration, the requirements of primary law are still fully applicable. So there is a requirement for supervision. There is a requirement that the supervision is independent and has binding powers. So how does this look like more concretely? In a law enforcement context, what's interesting to know, and you probably noticed, is that there is the Law Enforcement Directive, which we had heard about this morning, but there's a lot of other legal frameworks on EU level which have rules related to data protection and which are relevant for the law enforcement context. I put some of them on the slide, but actually I don't think it's all of them. That's why I also included 3 dots. There is like these rules that relates to the EU agencies that we have in the law enforcement context, so Europol, Eurojust, the European Public Prosecutor. There is rules related to the different databases, so the Visa Information System, the Schengen Information System. All these different rules have data protection aspects, and they all kind of are interrelated. So we have this patchwork in a law enforcement context. So the patchwork in the 3rd pillar, which the title of this presentation related to. Of course, this patchwork also means that supervision in a law enforcement context for data protection purposes is not that simple. It's also a bit patchwork. But one broad distinction you can make for all these different legal frameworks is that there are some sort of 2 types of supervision. On the one hand, you have supervision of the national authorities processing personal data, which is usually done by national supervisory authorities. On the other hand, you have supervision of the EU part of things, of the EU agencies, but also of the EU part of the management of these large databases. So these are the 2 aspects. But of course, in a law enforcement context, you cannot separate them that easily, because if you, for example, work with Europol, then you have the national authorities working with the Europol database. So you have both the EU element and you have the national element. So these also need to kind of interact and they need to cooperate, which makes this area so complex, but also very interesting. I cannot discuss with you all the supervision provision in the different law enforcement frameworks, because as I said, there are very many, but I was thinking we could look at them in 3 examples and then go from there, because also these 3 examples are relevant for the EDPS decision. So first example, and you heard already about this morning, so we can go through this a bit more quickly, is we have supervisory authorities in the Law Enforcement Directive, which are for the national authorities processing personal data. As you have heard, you can have one or more such authorities. Again, Belgium is, I think, the only one who has more than one. And also maybe, I think now, not the only one, but with Sweden, one of the few ones who actually have a specific one for the Law Enforcement Directive. So this is one way. And what's interesting, what Anna also mentioned, is that you can actually have the same data protection authority for law enforcement and the GDPR. Maybe afterwards in the discussion, if any one of you works at such authority, does do both, I would be very interested to hear how this works, because I think it's like a very broad scope of fields that you then have to cover. Of course, the authorities in the Law Enforcement Directive cooperate like under the GDPR in the context of the EDPB, and there they work on guidance, especially guidance for law enforcement, like for the GDPR, but they have so far published 2 pieces of guidance for the Law Enforcement Directive, specifically like the adequacy referential, which is on the transfer of personal data. And in May this year, so very recently, one on facial recognition, which I think is a bit more comprehensive because it covers a lot of the different rules of the LED. Okay, so now we know that there is these authorities. So what can these authorities in the LED actually do? Their task, of course, is to ensure compliance with the Law Enforcement Directive and also to help data subjects exercise their rights to a certain extent. Their powers, I would broadly summarize into 3 sort of broad categories. They have investigative powers. This means that they can actually gain access to personal data which is processed by Law Enforcement Directive to make sure that they can investigate properly. They have corrective powers, so they can issue a warning, they can order compliance, like they can order to delete data like the EDPS did. And they can also impose bans on processing. And finally, they have the power to bring an infringement to court. This is actually an important one. I don't know if you're familiar with the Schrems case. The Schrems case was from 2015. It was a case about data transfers. And the problem with data transfer is if there is an adequacy decision, which is one of these mechanisms you can use for them. So for data transfers to third countries. If there's an adequacy decision, principally it's an act of EU law. So it's something that the Commission has adopted, and principally it's EU law, so you are bound by it. But the question in the Schrems case was, okay, as a DPA, you're bound by this decision, but if you have a complaint by an individual, what do you do then? Because of course, the national court or national authority cannot say that an act of EU law is illegal or there's a problem with it. This is a task that's only for the Court of Justice. So in the Schrems case, the Court of Justice said that data protection authorities, and I think that that's also true for the law enforcement context, also always must have the opportunity to bring a case to court, so it can get eventually referred to the Court of Justice, so they can make a decision if there's a problem, or like if there's an allegation that there's problems with EU law. There is, under the Law Enforcement Directive, if you see on the slide, no power to issue administrative fines, or at least it's not obligatory. I don't know if that's still done in any national member states. Maybe there's also something we can discuss in the Q&A. So the next example is the Europol Regulation, and here I have to make a clarification. This is, of course, the Europol Regulation before the reform that was decided upon last month. So under the Europol Regulation, you have 2 types of supervisions corresponding to these 2 types that I told you before. So you have on the one hand, the national elements. You have national supervisory authority, seeing what national law enforcement authorities are doing with the Europol database. On the other hand, you have the EDPS supervising Europol as such as an agency. So you have these 2 elements. And then you also have a cooperation board where the 2 are supposed to talk with each other and exchange best practices. The powers of the supervisory powers over Europol are also divided in the national and the EU level. On the national level, the law itself only talks about investigatory powers so that they can access data to do the investigations. But of course, this is going to be regulated in national law, so there might be more powers there. The EDPS has the same 3 types of powers that we saw before in the Law Enforcement Directive. So again, investigatory, also corrective, so they can warn, they can order erasure like they did in January. and they can also refer cases to the Court of Justice. They don't have, under the old Europol regulation, a power to issue administrative fines. As I will tell later, this has changed now. And then the cooperation board only has kind of advising and coordinating powers. It kind of helps dispute resolution, but it does not really have this formal sort of binding decision-making powers that you see, for example, under the GDPR. And then finally, let's look at the EU DPR. The EU DPR is the regulation for data protection in the EU institutions. So this includes all these institutions with the law enforcement brings in principle, so Europol, Eurojust, etc. But of course, it's because it's law enforcement, it's a bit special, it's a bit complicated. So if you look here at the scope of the UDPR, you can see that there is sort of an exception, but it's a bit complicated to describe because it refers to all these chapters, etc. So I will try to translate. So basically, what this paragraph 2 here means is that UDPR, only parts of it apply if we have processing that falls under chapter 405 of the TFEU. And chapter 405 of the TFEU are, of course, the area of freedom, security, and justice. So this is law enforcement cooperation, also judicial cooperation in criminal matters. So to this area, we only have one chapter and one article of the UDPR applying. And then if you go one below, if you look at Europol and the European Public Prosecutors, EPPO, here, even this one part does not apply to the processing of operational data. And operational data, which is defined also in UDPR, is data that relates to the area of freedom, security, and justice, so law enforcement data. So if Europol and EPPO process law enforcement data, the UDPR does not apply, but it applies if they have administrative data. So this is important to remember. Of course, this exception is only until the rules are changed. And I just told you, Europol rules have changed. So now this exception is also not true anymore, for Europol at least. And why is the UDPR important, especially for our discussions today, is because, of course, it establishes the EDPS and it describes the power of the EDPS. What's interesting is that the EDPS under the UDPR has more powers than it actually has described in the Europol regulation, as I showed you before, because under the UDPR, for example, it can issue administrative fines, although again, this has changed now also for Europol. So you see, this is all a bit complicated in the law enforcement area. We have a lot of authorities who are competent. We have these two areas, always the EU area and the national area. We have a need that they cooperate. We have some sort of mechanisms to help that, but it's really a bit of a complex patchwork picture. If we then think back to the Europol decision, what can we learn from this patchwork? I think here it's interesting to go back a bit to the timeline of the decision. So we had first in 2017, EDPS, who becomes the supervisory authority for Europol. We then have in 2019, Europol informing the EDPS actually that they have this problem with these big data sets that they received from the member states, and that they're not sure how to handle it within their own IT systems and what procedures they should use for this, and that there were some problems. The EDPS then starts the investigation and already in 2020 issues a sort of warning or admonishment for Europol for some of the issues it discovers, including the one on data subject categorization, so that these data sets had no categorization, so there was no clear link for all this personal data to a law enforcement context. But in 2020, the EDPS said it wants to give Europol a chance to sort it out themselves. It gave some timeframes until when it expected a solution, but it did not order anything concretely yet. This was a decision from September 2020. In December 2020, the Commission published its proposal for a recast of the Europol Regulation, which also includes some rules on large data sets and how to handle them better. This reform was always planned, but it was taken 15 months earlier than originally intended. So it was always clear that the Europol Regulation of 2016, which was already pretty fresh, would eventually be reformed, but it was done a bit sooner than expected. Then, of course, in January, we had the decision by the EDPS ordering Europol to erase the data, giving them 1 year for all the data they already had, and saying that for the future, they have 6 months to make sure that all the data they received is categorized and has this clear link to law enforcement. And then in May 2022, the European Parliament has approved this recast, which is the last step in the formal adoption process. So I think we will have soon everything published in the official journal. From a supervisory perspective, I think it's nice to see that the EDPS took the step. This was the first time they used this power to order something. But it's also interesting to see that this whole investigation only started because Europol told the EDPS that there was a problem. So this is also an interesting kind of positive form of cooperation between the authority that was being supervised and the EDPS as the supervisory authority. Of course, the timing between the reform and between the decision was not taken without criticism. There's, for example, this article in the European Data Protection Law Review by Teresa Quintal, who says it's kind of like they were found to do something wrong, and then a few months later, it's kind of retroactively legalized by the reform. Of course, you can have different opinions. So this is, of course, one criticism that has been made, not just by Quintal, but also especially by digital rights organizations who also voiced a lot of fears that the extension of powers for Europol is going a bit too far. I don't want to go into all this discussion. Of course, we can see a bit in the Q&A, but I think what's interesting here from the perspective of fundamental rights is, of course, this is a bit this question. Is it okay to you have a decision by a supervisory authority and afterwards you have a law kind of taking away the legal basis for this decision? So this is one of the questions. I don't have a final answer yet, but I also have to, I thought about this a lot, and I think it's not that unusual actually, like that you have a decision by a regulator and then afterwards the legislator decides that this is not the type of decision that they had in mind. And it is there. They can change the law, and that's what they did here. Of course, if it affects individuals retroactively, this is usually a problem, especially a problem in criminal law where it's actually prohibited. So the question I think that we need to ask ourselves here, is this a decision that is affecting individual? Of course, it means that personal data that has not been categorized, which might relate to innocence, is going to be continued to be processed. So this might be a problem, but I think we still need to think about the details a bit more. What I find also interesting in Quintal's article is that she also said that with this reform, one problem is that when it comes to large data sets, there is no obligation of Europol to inform the EDPS in advance of what they're planning to do. And as we've learned before, one key aspect of the EDPS decision on Europol was that they were informed by Europol themselves, and this is when they started the investigation. So she argued this is actually an important part of the supervision, and this can make it more difficult if this is not there to have effective supervision. The EDPS, of course, also had its thought on the Europol regulation. They were maybe less critical, but they said that one thing that's important is that any sort of extension of powers by Europol should also come with an extension of powers by the EDPS. And on this aspect, it was not fully satisfied with the powers it had received. But of course, this opinion was before the final trialogue conclusion was reached, so we don't know what it now thinks about the final results, but actually did get a bit of extension of powers. What are the lessons we can draw from this decision? I think this point that Quintal makes that it's important to have this notification about certain activities so that the law enforcement, like the supervisory authority, can get involved is an important one, but I'm also happy to hear from your perspective, especially if you're working in a data protection authority, how important is that? But I think especially if you are an authority that has a lot of different competences, and maybe you are GDPR, also law enforcement directive, it might be important that you have like this notification so you can be a bit, have an overview of what's happening and can plan a bit better where you should intervene. So I think this might be indeed an important aspect. The second thing that I think we learn is that if there's problems on a national level in a law enforcement context, because everything is so connected, it can sweep up to the EU level. What do I mean here? Of course, data subject categorization, as also we learned in the first presentation this morning, is an obligation that's also there on national law enforcement authorities because of the LED. So under the LED, you're actually always required to do this data subject categorization. So in that sense, that such large data sets were sent without such categorizations to Europol is also a problem that would have to be addressed at national level. I have not seen if there was any decision on national level that this was an issue. Maybe there were, maybe you know about it. I don't think so, but it would have been nice to see. And of course, it shows that national level and EU level kind of have to work together to address some sort of problems, because these kind of systems are so intertwined. All right, now let's go to the final part of this presentations, a bit on the way forward and how we can address maybe this patchwork of law enforcement supervision. As I said, there is a lot of different frameworks in law enforcement context. It's a special area, and I don't think that this sort of big patchwork is ever gonna go away very quickly. So I think we will have to live for a while with data protection and law enforcement context being split over a lot of different rules and being rather complex for that perspective. The causes for this patchwork are, of course, that we have, on the one hand, this declaration that I told you about in the beginning. On the other hand, we also have this shadow of the third pillar, how Diana Dimitrova calls it, which she wrote a very excellent PhD about this. And I think also this frame shadow is very great. So this kind of is still with us. So the third pillar, this pillar structure was abandoned, but it kind of lives on in law enforcement, and it kind of still casts a bit the logic, and the discussions are a bit like this. So I think for those two reasons, we can also not expect this patchwork to end anytime soon. So how can we then address it? Because of course it's a patchwork, it's complex, but maybe we can still work with it for the best outcomes for especially the data subject. I think I discovered that there's sort of two strategies that are being pursued at the EU level to deal with this patchwork. On the one hand, we have the Commission who's doing this sort of reviews against a certain standard. So in 2020, the Commission published this communication where it reviewed different law enforcement tools, which were focused on this national level, against the standard of the Law Enforcement Directive. So I think the goal of the Commission, if I understood this communication correctly, is that at least every standard in law enforcement should align to the LED if it concerns national authorities. Within this report, it reviewed 26 acts in the law enforcement context, which already shows you how many acts there are. And it found for 16 that there was no need to do any alignment, either because it was already kind of aligned or because they were already opening it to reform it. For 10 acts, the Commission did find a need for further steps, for example, the Customs Information System, the Mutual Legal Assistance Treaty with Japan, the European Investigation Order, also the PNR Directive. On some files, there has since been progress. I'm very interested in the Mutual Legal Assistance Treaty with Japan because it concerns data transfers, which is kind of one of my favorite subjects. And here we saw already some proposals of the Commission, what would be the objectives for the renegotiations. The negotiations have also started. And the goals the Commission set it are quite positive and really in alignment with the Law Enforcement Directive. So I'm very curious what will be the outcome of this. On the other hand, the UDPR, so this instrument for data protection in the EU institutions, also has this obligation for a review. And this is a review of union acts with data protection, and that they're all aligned with the EU DPR, especially those in the area of security and justice. This report was supposed to come out until the 30th of April. I have not found it yet, so I think it's delayed. But I think it follows the same system. So the idea is that all law enforcement instruments with the EU institutions involved should align to the standard of the EU DPR. So then in the end, you would have one standard on the national level, the LED, and one on the EU level, the EU DPR. And this kind of makes it a bit easier to anticipate the kind of rules you will encounter, and maybe also to foster a bit the coordination between both. On the other hand, what we see is that there is initiatives to ensure that this talking between the national level and the EU level is happening in a more coordinated manner. So in 2020, in the framework of the EDPP, they organized the Coordinated Supervision Committee, which is like national supervisory authorities and the EDPS working together on the systems where they kind of have to work together. So far, they're supervising Eurojust and the European Public Prosecutor, but they want to extend it especially to the large-scale IT systems like Schengen and the visa system like ATS, all these different acronyms. They want to extend it to this and make sure that there is coordination on all these files. They meet twice a year. They have a work program that's published, and there they want to especially focus on data subject rights, but also on how to do investigations, how to do joint investigations, how to do audits, and just information exchange. There's not much information what they decide, etc. So transparency is definitely something that could be improved, but I think in general this is a very positive initiative that hopefully will ensure that there's good communication between these two aspects of supervision. Okay, this leads me to my concluding remarks. What I want you to remember from today: we do have a patchwork of rules in a law enforcement context, which also means that there's a bit of a patchwork for supervision in data protection in a law enforcement context. There is this divide between the national level and the EU level, which are, however, very much intertwined because most law enforcement operations kind of include both. The EDPS decision for Europol shows that the EDPS has successfully exercised its powers. It's taking its role over Europol seriously, and it's kind of a good example of how supervision should be done. Of course, the Europol reform comes at a bit of a difficult timing. We'll see what this actually means, but if the decision does confirm also this link between national level and EU level, and that problems that are on national level will eventually spill over to the EU level. And then finally, we saw that there's currently two sort of approaches to help against the patchwork. We have these reviews done by the Commission, and then we have this coordination efforts between the different supervisory authorities. Is this enough? I think they are very recent initiatives starting in 2020, so we cannot quite say if it's enough. I think it's promising, but I'm also happy to discuss with you if you think we would need more measures to counter this patchwork. I'm looking forward to your points, and this is also where I want to close, and I'm looking forward to the Q&A.